Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between, yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between, yeah.
All right, welcome back, y'all. Come on in, have a seat. We are here for part 2 of Armon versus Donat. Now, the first video was Armon requesting for a restraining order petition. Now, this second part would be Donat's rebuttal. Now, this court document is notice in motion of defendant Donat Ricketts. Motion to strike plaintiff's request for civil harassment restraining orders, memorandum in support thereof, declaration of Donat Ricketts. All right, now before we actually get started, scrolling at the bottom of your screen is my copyright disclaimer on the section 107, just simply saying, hey, this is fair use. I am not a paralegal, I am not an attorney, and I am also not a judge. Also, top left-hand corner of your screen is my QR code, direct link to X, plethora of other court cases. You can get the discussion popping or however you see fit. Now, let's continue. So here is Donat's rebuttal to Armon's petition for a restraining order. So as y'all can see here, it says, please take notice that on January the 23rd of 2026 at the Metropolitan Courthouse at the address listed above, defendants moves this honorable court with a motion to strike plaintiff civil harassment prevention, also known as PRO, pursuant to California Civil Code of Procedure 435 on the following grounds. Plaintiff's PRO, page 2, section 4, relationship of parties, attachment 4. These statements are vague, ambiguous, improper, scandalous, false, and irrelevant because plaintiff has not and cannot meet the legal burden for stalking, credible threats, in or point to any conduct which serve no legitimate purposes. All right. So then he continues to say, plaintiff's PRO, page 2, section 6, other court cases. This is improper, scandalous, perjured, and irrelevant because plaintiffs has nothing to do with defendant's criminal case, nor does he list any additional persons in item. Plaintiff's PRO, page 2, description of harassment, attachment 7. These statements are vague, ambiguous, improper, scandalous, false, and irrelevant because plaintiff has not and cannot meet the legal burden for stalking, credible threats, violence, and or point to any conduct which serve no legitimate purposes. And then plaintiff's PRO, page 4, section 9, which is the stay away orders, are improper, scandalous, false, and irrelevant because the complaint doesn't allege any personal contact which serve no legitimate purposes. Plaintiff seeks to shield defendant's First Amendment right. And as y'all can see there are the Code of Civil Procedure, which is 436A. Then he goes on to say, plaintiff's PRO, page 5, section 13, no fee for filing of service. Plaintiff has not and cannot meet the legal burden for stalking, credible threats, violence, in or point to any conduct which serve no legitimate purposes. Plaintiff is not entitled to a fee waiver and should bear all costs associated with litigation. This motion is based on this notice of motion in motion accompanying a memorandum of points and authorities, plaintiff's request for restraining orders, the pleadings and papers filed in this action, in such further argument and matters as may be offered at the time of the hearing on this motion. So now we're going to get into the memorandum of points and authorities in support of motion to strike portions of plaintiff's petition. Introduction: both Armon Wiggins and Donat Ricketts are social media influencers and new media reporters who attend public events and high-profile court hearings throughout Los Angeles and the United States of America. Wiggins has been a new media reporter for at least 10 years with a combined social media following of more than 600,000. Wiggins specializes in, oh, Jesus. Okay. I just saw the pouring baby oil, but we're going to get to that. I just saw that. So I'm like, oh, Lord. Okay, so here we go, y'all. Wiggins specializes in covering female rappers, social media personalities, and tarot card reading. Wiggins is best known for pouring baby oil over his naked body outside the New York Southern District. Oh, got tongue tied there. New York Southern District Federal Court on July the 2nd of 2025 in celebration of Sean Diddy Combs' beating racketeering charges. He wishes to rise above new media reporting and become a Hollywood actor. Ricketts, on the other hand, is an accredited actor. He became a new media reporter in 2023, specializing in Black celebrities, true crime, politics, and does so utilizing his background in stand up comedy, acting, and broadcasting. In early 2023, Wiggins contacted Ricketts via Instagram and immediately began attempting to use him as a proxy to sway public opinion in his favor. Ricketts quickly notified Wiggins that he could not use his talents and influence for his self interest. As a punishment, Wiggins has continuously spread misinformation about Wiggins, accusing him of stalking, which is a crime in the state of California. In the worlds of Wiggins, he showed Wickets how to YouTube, thus admitting to his scandalous tactics. And as y'all can see there, right there, this is a hyperlink to eonline.com news, which shows it says Sean Diddy Combs' verdict, and it says support or celebrate. So I'm assuming that this is the video, as y'all can see here with the baby oil incident. All right, let's continue. It says Ricketts has informed Wiggins on numerous occasions that such defamatory statements have caused him multi-dimensional harm, a false light defaming narrative. Wiggins used his large platforms to control public opinion about Ricketts. I'm sorry, I just been reading. Maybe I said his name wrong in the past, but it's Ricketts. Thus, suppressing his growth, brand opportunities, and tarnishing his reputation. Beside court trial attendance, Wiggins has not and cannot present any evidence of personal contact since July of 2024, even though he's had the same address and phone number before meeting defendant. Plaintiff is known for cyber stalking women. Oh, y'all, there's some tea where I got some tea. Oh my goodness. So y'all can see here, he put Tasha K, he put Nicki Minaj, Cardi B, others. Okay, so let's start here. Tasha K. Wiggins is famously known for accepting a mentorship with new media reporter Tasha K. Over 6 years ago, after 21 days, plaintiff launched a hate campaign against Tasha K by doxing, cyber stalking, harassing, and bullying her. A search for Tasha K on plaintiff's YouTube channel will collectively display hundreds of videos, whereas he received thousands of monetized watched hours and donations for his hate campaign. And then it says, as y'all can see there, there's a hyperlink to a YouTube video. Nicki Minaj is next. Wiggins is famously known for his brief acquaintance with female rapper Nicki Minaj. After she ignored him, he launched a hate campaign against Nicki Minaj by cyber stalking, harassing, and bullying her. A search for Nicki Minaj on plaintiff's YouTube channel will collectively display hundreds of videos, whereas he received thousands of monetized watch hours and donations for his hate campaign. Nicki Minaj eventually responded, begging plaintiff to cease his string of behavior. And then there go a YouTube hyperlink there. And also a hyperlink to hot new hip hop news. Okay, now Cardi B. Wiggins is famously known for his brief acquaintance with female rapper Cardi B. After she ignored him, he launched a hate campaign against Cardi B by threatening to release illegal recordings, cyber stalking, harassing, and bullying her. A search for Cardi B on plaintiff's YouTube channel will collectively display hundreds of videos, whereas he's received thousands of monetized watch hours and donations abetting his hate campaign. Cardi B eventually responded, begging him to leave her alone. And then it shows that there is a hyperlink to her spaces on Twitter. And then it says D, which is others' pattern of behavior. It says Wiggins would not be as popular on social media without his mentorship with new media reporter Jason Lee in Hollywood Unlocked. Once Wiggins' true character was exposed, he launched a hate campaign against Jason Lee and his Hollywood Unlocked brand by doxing, cyber stalking, harassing, and bullying him. Wiggins' most viewed live stream video on YouTube is of him having a manic episode while burning Jason Lee's book and promising to quote unquote stay on his neck. And then there's a hyperlink to the YouTube video. Wiggins has doxed, cyberstalked, harassed, and bullied countless others throughout the years, many of whom once trusted him, helped him, and most are black. Oh, he said most are black women. Wiggins displayed a manic episode against new media reporter Claudia Jordan and other co-workers, which led to him being blackballed from Fox Studios LLC. And then there is a hyperlink to the YouTube channel. And then it says argument standards for motion to strike. A motion to strike may be used to cut out any irrelevant, false, or improper matter inserted in any pleading. The grounds for a motion to strike shall appear on the face of the challenge pleading or from any matter of which the court is required to take judicial notice. Section 4, which is relationship to parties. Wiggins states, we met in 2023 and were acquaintances briefly. In 2023, he attempted to attack me and we ended up in a physical altercation. Since that time, we have not had any personal or friendly relationship, but he has continued to harass and threaten me online and in person. First, on September the 21st of 2023, Wiggins created a YouTube broadcast confirming he and Ricketts both attended two separate Zeus Network events. In his video, Wiggins referred to Ricketts as quote unquote mentally ill, dubbing him as a stalker. Wiggins' aggressive gesture and statements between the 8:30 to 10:30 time code on the video confirms that he committed an assault against Ricketts, which prompted a physical altercation. And that is a hyperlink to that particular YouTube video. And it says from here on, the plaintiff would refer to defendant not by name, but as his quote unquote stalker, which has been duplicated within, and then we're going to scroll down, hundreds of videos by multiple content creators across multiple social media platforms. This was Wiggins' way to showing Ricketts how to YouTube. Second, plaintiff perjured himself when he states, since that time, we have not had any personal or friendly relationship, but he has continued to harass and threaten me online and in person. Because on December the 3rd of 2023, Wiggins took Ricketts' cell phone and snapped 5 selfies. Therefore, Wiggins mooted all prior claims of harassment. He knowingly and willfully omitted this important fact from his petition as a deceptive tactic. Wiggins has displayed a willingness to lie to this honorable court. Section 6, which is other court cases. Wiggins is not a victim, witness, nor does he have any personal knowledge about Ricketts' open criminal case. Wiggins did not list any additional people, nor could he provide evidence suggesting he knows the alleged victim. Indeed, Wiggins was desperate to deceive this court into granting his TRO and by bolstering allegations of an attempted attack set forth in Section 4. Now let's look at Section 7. It's the description of harassment. Wiggins states on Tuesday, November the 26th of 2025, while I was covering a court case in Miami, the respondent confronted me inside the courthouse bathroom. He called me derogatory names, became aggressive, and told me he was going to fight me. An officer of the court was present and witnessed the threat. When we returned to the courtroom, the judge stopped the proceedings to ask who was being threatened. and a lawyer informed the judge that he heard the respondent making threats towards me. First, this honorable court doesn't have jurisdiction over allegations involving an alleged incident inside a Miami, Florida federal courthouse. And as y'all can see, I guess he scratched this out and put Wiggins did not file a police report, nor does he provide any specific statement to support his allegation. Most importantly, Wiggins was not in Miami, Florida on November the 26th of 2025. Second, on October the 9th of 2025, Ricketts created a video announcing that he'd be attending Megan Pete versus Milagro Elizabeth Cooper in Miami, Florida. And then there go the YouTube hyperlink there. Then on October the 15th of 2025, Ricketts created a video stating he would not be attending the civil trial in Miami, Florida. And if so, he's going to fight Ricketts. Wiggins was in fact referring to Ricketts as indicated within Ricketts' request for restraining orders, and because it was public knowledge that he'd be attending the civil trial. Third, Ricketts arrived in Miami, Florida on Saturday, November the 15th of 2025 to attend Megan Pete versus Milagro Elizabeth Cooper civil trial, which started on Monday, November the 17th of 2025. Same day after watching Ricketts' coverage, Wiggins created a video disparaging and begged his subscribers to cover his travel expenses. Plaintiff spent thousands of dollars, shifted his freelance schedule, and traveled more than 2,500 miles to put himself in Ricketts' vicinity, even though his request for restraining orders claim he's been afraid of Ricketts since 2023. Therefore, based upon Wiggins' own acts, all allegations or threats, of threats and harassment from 2023 up until November the 18th of 2025 are a moot point. Furthermore, on November the 21st of 2025, plaintiff is in video standing arm's length away from defendant and talking loudly. And then there go a quote, not a quote, but a hyperlink from an Instagram live. So again, by way of Wiggins' own actions, he voided all claims of reasonable fear and or emotional distress. Fourth, Wiggins states on November the 29th of 2025, he posted a direct threatening message toward me on x.com stating, "I'ma stay on your neck, coward." This message was targeted at me by name and continues his ongoing escalation. However, this is a partial statement Wiggins couched as a credible threat is contradicted by his own submission of the actual tweet, which reads in full. Armon Wiggins, since you're not beefing with nobody that makes less money than you, why spin narratives to make people hate me? Is it because that's how you stay on top? I'm going to stay on your neck, coward. And then it shows C. Wiggins Exhibit A. Wiggins' act of misrepresenting material facts is abundantly clear within his unintelligible requests for restraining orders. Moreover, Derek Chauvin, however you say his last name, is not a defendant in this action. Fifth, defendant's tweets and online statements are protected under the First Amendment. Run a fade or STFU. Anyone claimed to fame is off commentary and stand culture don't rank to me. And the inclusion of defendants imbd.com URL is a long-standing challenge for a boxing match. Such post is not a credible threat to plaintiff, but an invitation to mutual combat in a controlled professional setting that will ultimately help plaintiffs transition from YouTube to Hollywood. And then he quotes, as you can see, a hyperlink to a Netflix, which is Jake Paul. Okay, so let's continue further. Defendant has challenged other YouTubers to a boxing match. Moreover, Ricketts' conduct must, by its nature, be such as to cause a reasonable person to suffer substantial emotional distress it must cause substantial emotional distress to the plaintiff to be enjoined. Section 9, which is stay away orders. Plaintiff's restraining orders, because a major part of my job requires me to be inside courthouses reporting on legal proceedings, I cannot avoid these locations. I am requesting protection so I can safely work without being threatened, confronted, or harassed in person or online. Plaintiff has not and cannot provide evidence that defendant made personal contact with him beyond the scope of attending public events, specifically at courthouses. Courthouses are the safest and most secure places in America. Thus, the principal thrust of plaintiff's petition is to eliminate competition by barring defendant from attending public events, a constitutionally protected right. Then Section 13, no fee for filing or service. Plaintiff has not and cannot establish that defendant threatened him, used violence against him, or acted or spoken in any way that would put him in reasonable fear. To the extent that one would ponder, plaintiff's act of taking photos with defendant and traveling more than 2,500 miles to be in defendant's vicinity and standing arm length away from defendant after allegedly being threatened in a restroom weighs against plaintiff's request for restraining orders. Furthermore, as plaintiff pointed out in defendant's tweet, Armon Wiggins, since you're not beefing with nobody that makes less money than you, the plaintiff should bear all costs associated with this litigation and be ordered to pay the marshal for service of a frivolous petition. And this is the conclusion. Based on the foregoing, plaintiff's request for permanent restraining orders should be stricken and denied. Ooh, excuse me. And then this is just the declaration of denied. Now, y'all can pause your screen and read this. Now, y'all know I will also have this in the description box below so you can actually read this for yourself. But this is the NOT's declaration.